I am going to do a brief trial history on defamation of public figures. So a quick preview for you. Give me 1 second here. I'm going to walk through career aspirations for myself because that's an important piece of this presentation. Key terms that everyone is aware of the terms mentioned in the cases. Then I'll go over a trial history of influential cases, including New York Times v. Sullivan, 1964 case. Then Associated Press v. Walker, 1967 case, and then talk about what the difference is between a public official versus a public figure is. Understanding these differences are important, especially for a career that I'm interested in. And finally, talk about how those cases and the difference between a public official and a public figure has implications on my future career. So first, career aspirations for myself. I want to do something in public service, and public service can look at a lot of different ways. One of which is working on a political campaign as a communicator. I'm a strategic communications major, so that's interesting to me. Working for a politician who's already in office, running for office, or serving as a politician. So campaign side or working as a politician, either or. But either working in the communication field in public service, but understanding defamation is important. And one of those reasons is that campaigns utilize others to provide evidence, negate claims, and attack others. And I know all of us are familiar with attack ads, but rarely do we think about what goes behind creating those ads because it's not, we think about how horrible they are. When in reality, there has to be a lot of questions asked about: are we appropriating someone's likeness? Is this done with malice, etc.? And so I'm going to play you a few ads just so you can watch these ads with that frame of reference and see what I'm talking about as I reference throughout the presentation.
I'm Bill Nelson, and I approve this message.
With a history of bar brawls, altercations, and road rage, a trail of unpaid debts and tax liens, one of the worst attendance records in Congress this year, while still taking his $174,000 salary, and a plan that could cut trillions from Medicare, Social Security, and defense. No wonder Florida's newspapers have said Connie Mack IV is in no way qualified to be a senator and has no business holding any elected office.
I'm Todd Aiken, and I approve this message.
It's a corrupt Washington game, and Claire McCaskill plays it, getting rich off government. McCaskill cut funding for education and veterans, but partnerships owned by McCaskill's family received over $1 million in stimulus spending. Now a new scandal. McCaskill's family pocketed $40 million in federal subsidies. $40 million of our money. Corrupt Claire. The moment her hand came off the Bible, it went into our pockets.
So I hope those videos were helpful to you. After watching those and taking this course, it really helps frame how difficult those ads are to pull off, especially when there's so much right of publicity and likeness used in those, and it's cutting a close line between malice and defamation. And so it's really tricky to pull off, and so understanding that and the line for someone who's going into the public service field is really important. So some key terms that I want to highlight before we start reviewing our cases. First, defamation. As we know from throughout this course, it's the false statements that damage the reputation of someone. A public official is someone serving in office generally, and that's a little bit of a caveat, but rule of thumb, it's easy to tell if they're a public official if they've been appointed into office, they're a judge, they're a mayor, they're the president of the United States. Public figure, someone pervasively involved in public affairs. So think about Paris Hilton, think about someone who is just put into the vortex of public life without really running for office or being appointed to do so, but they kind of opt in themselves. Malice is knowing a statement is false or acting with reckless disregard for the statement's falsity. And this is the caveat to applying defamation to public officials. Right of publicity is the right to control others' use of their identity, and this was a major factor in the Keller v. Electronic Arts case previously presented on this course, and so just remember it's appropriating someone's likeness. So our first case, New York Times v. Sullivan. It's about affirming freedom of press. So the players in this case were New York Times, the newspaper, L.B. Sullivan, who was a city public safety commissioner in Alabama, so a public official. The facts of the case. New York Times published an ad for contributed donations to defend Martin Luther King Jr. on perjury charges. And Sullivan felt that the ad reflected poorly on his employees. So on the right side of the screen, you can see that was the ad that New York Times published. And Sullivan thought that this ad was attacking his employees' jobs and who they were. But it's important to note and remember that Sullivan was a commissioner. He was in office for the city. So Sullivan sent a written request that the ad be redacted to the New York Times. He wrote them and said, "This is not fair to my employees. It's a bad representation of who we are. You need to redact this statement." New York Times refused to do so, and so Sullivan then filed a libel suit against New York Times and the African-American ministers mentioned in the ad. And if you can see that your help is urgently needed now, it lists out names, and Sullivan went after the Times and those African-American ministers. So the ruling. The state court ruled in favor of Sullivan, giving him $500,000 in compensatory earnings. New York Times then appealed to the Court of Appeals, and the appeal court supported Sullivan once again. So the New York Times appealed to the Supreme Court of Alabama. In 9-0, Times won, because the Alabama's libel law did not unconstitutionally infringe of First Amendment's freedoms of speech and freedom of press protection. And so those are the justices, all of which ruled in favor of New York Times and overturned the lower court's decisions. Justice Brennan provided the majority opinion and basically said to prove defamation, plaintiff must show that the defendant knew the statement was false or was reckless in deciding to publish the information without investigating its accuracy, meaning that Sullivan would have to prove that New York Times knew what was being published was false and reckless and still did it anyways. So when a statement concerns a public figure, it is not enough to show that it's false. Instead, the target of the statement must show that it was made with knowledge of reckless disregard for its falsity. And so this is where the caveat comes in that points to Sullivan being a public official, saying that he is in office, and therefore it's not enough just to say that it was hurtful or hurtful to reputation, but it had to be reckless disregard for its falsity, and Sullivan could not prove that, and so that's why the justice ruled in favor of the New York Times. So again, this sets a standard for public figures and officials, additionally, involved in defamation cases. And this is a really big win for media because it protects freedom of press and speech in covering public figures and officials. So that way, they don't have to be afraid to publish something that may be harmful to someone's reputation because it's directly related to their job as a public servant and as someone who's thrusted themselves into public life versus your shy neighbor. All right. Second major case, Associated Press v. Walker. The players were U.S. General Edwin Walker and the Associated Press, a media source. So the facts. AP, Associated Press, reports that Walker led a charge against marshals during a desegregation confrontation. Walker sued for libel, and AP could not prove the statements were true. Walker didn't like that this was being published because he thought it represented him poorly, that he was charging against marshals during desegregation confrontation, was worried about the social and political implications because of that. So the question that was raised was, should the actual malice standard be applied to cases of public figures? So we saw that was applied to a public official, L.B. Sullivan, but should that malice, that reckless disregard for falsity, still be applied to public figures? And is there a different standard for figures versus officials? So ruling. The trial court in Texas Court of Civil Appeals awarded compensatory damage to Walker because AP could not prove the statements were true. And punitive damages were denied because Walker could not prove malice. So in this case, we got a little bit of both sides. The court agreed that Walker should receive some sort of compensatory settlement because they couldn't prove the statements were true. But at the same time, he was a public figure, and so he would have had to shown actual malice, which he could not do in order to get punitive damages raised against AP. So, Supreme Court took on the case and so therefore determined Walker was a public figure given his personal activity amounting and thrusting his personality in the vortex of an important public controversy. So he was leading a charge. He put himself there. He wasn't appointed to. He willingly put himself in front of that group. And so that made him a public figure. The court decided that public figures could recover damages for false defamatory statements only on a showing of highly unreasonable conduct, constituting an extreme departure from the standards of investigation and reporting ordinarily adhered to by responsible publishers. So in simple terms, you can recover damages for defamatory statements, but only when you can prove that the conduct of the publisher was completely wrong, it was unreasonable, unfair to you, and it was straying away from standards of investigation that is generally adhered to by responsible publishers and publishers who have integrity. And so therefore the Supreme Court cannot prove actual malice. And so the court found AP's conduct to be reasonable. So this next is important because I think it gets, the line is slim, and so I want to make sure it's clear of what the difference is between a public official versus a public figure. So first, an official is elected. So take example, President Obama. He was elected into office. There's a higher bar because his job is to serve the people, and people deserve to know what he's doing, regardless if it's good or bad. And media shouldn't be afraid of influential and powerful people to do their job and to report accurately on what is happening in office. And so with that, you have to prove actual malice in order for President Obama to win a defamation case. Public figure, on the other hand, thrust themselves into public vortex, their societal influence, their pervasive power. Lady Gaga, or another singer or celebrity, is a good representation of a public figure. And they have to prove unreasonable conduct by a publisher, not actual malice. And so when we look at these cases, New York Times v. Sullivan, and Associated Press v. Walker, it's important because they're setting up standards for public officials and public figures in defamation cases. It's allowing the press to do their job in reporting without fear of persecution or being shut down by a higher power. And so honestly, this is a win for First Amendment rights because it allows our society to be freer, more transparent, and provide trust that our media is reporting accurately and without fear of being shut down for what they're reporting. And what happens when we don't have that is an example like North Korea. And so these are important and pivotal cases in First Amendment protections. So why this matters to me, working as a public official, again, I need to understand who is a public figure, who's a public official. If I'm using one of those people in an ad, what is the line? So I can share negative things about an opponent, but I can't go out of my way to destroy them with false facts, or false information, excuse me. And so I need to be cautious of that. Secondly, I think if I am a politician or I am on a political campaign, it's important to recognize when opponents are doing that to you. And so as a communicator on a campaign, potentially, I would need to be monitoring how people are using our image and how people are talking about our candidate to protect them and understand the line between them sharing information about a candidate and them defaming and using actual malice. And finally, intersecting with public figures as a public official or working for someone who is. So Like I said earlier, my work is going to intersect if I'm working for a public official or as a public official. My work is going to intersect with public figures. Constantly, public officials are with celebrities. Lady Gaga recently met with senators to talk about the Equality Act. And so it's important to understand the differentiation between that so you can always represent people in positive light, but also share facts that are not flattering, but do so in a responsible way. So with that, thank you for following. Thank you for a great semester of online learning. And I hope you learned a lot about the difference between public officials and public figures and how it pertains to my future career aspirations in public office. Thank you.